Well, hello everyone. Welcome to the Comparative Law series, a lecture series about comparative law as a methodology which given by comparative law experts from around the world. This event is a collaboration between Indiana University Maurer School of Law's Graduate Colloquium and Law as Science. Graduate Colloquium is an online meeting for graduate students at Maurer School of Law, where every other Thursday we discuss common academic concerns and research interests. My name is Eka. I am a third year SJD student at Maurer School of Law. I am also the coordinator of Maurer's Graduate Colloquium. It is really nice to see all of you here, wherever you are. I hope you are doing well. In this inaugural of Comparative Law series, the discussion about the general method for comparative law will be led by Simon Sun from Law as Science. Simon will be moderating the presentation and discussion by Professor John Reitz from Iowa College of Law. Simon, floor is yours.
All right, thank you very much, Eka. So I'm Simon Sun. I'm an SGD candidate at Maurer School of Law, Indiana University, and I'm one of the co-founders of Law Science. Law Science is an academic initiative created by Professor Meki and me. We aim to promote the study of law by bringing diverse methodological perspectives on the different issues of law. If you are interested in more law science events, please join our email list by clicking the link we have shared in the chat box. Today, we are very honored to invite Professor John Reitz to talk about the general methods of comparative law. Professor Reitz received his bachelor's degree from Harvard in 1970 and JD from University of Michigan in 1975. He is currently the Edward Carmody Professor of Law and Director of the Master's and Doctoral Degrees programs at the University of Iowa College of Law and the Director of the Visiting Scholars Program. He practiced law in private firms in Washington, D.C. from 1975 to 1983. When he joined the Iowa Law faculty, he has become a full professor since 1988. Professor Reitz focuses his teaching and research on comparative law, introduction to U.S. law for foreign trained lawyers, and administrative law. He is the chair of several SJD dissertation committee and advisor to LLM students. His major focuses for research and writings are the way in which differences in countries' political economies are correlated with differences in their legal systems, the development of the rule of law, especially after communism or other authoritarian forms of government, and comparative administrative law. He is the titular member of the International Academy of Comparative Law, past president of American Society of Comparative Law from 2010 to 2012, permanent visiting professor at Zhejiang University Law School in Hangzhou, China since 2008, visiting professor at universities of Münster in 1994, and Freiburg, um, Germany, and the Victoria University in Wellington in New Zealand. He has lectured on US and comparative law topics in China, Hungary, India, Nigeria, Poland, Romania, Russia, Taiwan, Tajikistan, Ukraine, and Vietnam. He has served as comparative law consultant to Ford Foundation in China, United Nations Development Project in Vietnam, and the US Department of Justice. He is the author of numerous articles and books chapters, and is the co-author of Constitutional Dialogues and Comparative Perspective. So during Professor Wright's speech, we welcome the audience to put your questions in the Q&A chat box. And I will help moderate those questions during the Q&A session. Without further ado, the floor is yours, Professor Wrights.
All right, thank you very much, Mr. Swin, and thank you to Mr. Putra for inviting me here, and to the University of Indiana for sponsoring this. I'm very honored to be part of this group, and it's a great opportunity for me to explain an idea that I've been developing for a long time in my career, namely a kind of a general method for comparative law. Now, let me ask, I should have clarified this before we started, but can I share my screen with people? Okay, now let's see. What I want to do, let's see here. I think I just need to figure out which screen I'm sharing here. I'm going to I have a little outline of the talk, and so I thought I would put that up so you can follow along. It's not a detailed outline, but I thought it might make it easier to see the where I'm going. So I'm going to share this, if I can figure out how to do it. Let's see, here we go. And I want to share screen too. Okay, so now if I, and then I have to press share. If I did this right, you should now be looking at my general method, okay? Wait a sec. You should be looking at my, wait a sec. You should be looking at an outline. I'm not sure I did that right. Let me try that again.
That's what we see, a general method.
But do you see, is it just one page, or is it multiple? Oh, okay, because I'm paging through right now on my screen. I'm seeing the, never mind. Okay, I think I did it right. Okay, so sorry for that. What I wanted to say is, I just wanted to say a brief word about the title of this esteemed organization that's invited me. I'm not a big fan of thinking about law as science, because I tend, whenever someone talks about science, I think of the modern 20th century, 21st century view of science as part of STEM. And I very firmly believe that law is part of the humanities. It's basically a form of rhetoric. And we should never forget that. We should, of course, use science and be aware of it. And talking about legal science is not a bad idea, as long as we keep in mind the ancient Latin and Roman view of what scientia, science, meant. It means knowledge about. It doesn't mean STEM stuff necessarily. I'm not opposed to STEM by any means. I've written in favor of using statistical analyses carefully in comparative law. I've also been a critic of the way it's been used in many cases. But I just wanted to say that I come from a view of law as part of the ancient topic of rhetoric, and that's the way I think of it. Now, I've been developing this, and it sounded to me from the way the organization was described that that's probably not contrary to your own views, but I just thought I would mention that at the beginning. Now, this general method, I've just a word or two of introduction about it. It's something I've been developing over my life as a teacher of comparative law, and it really primarily comes from my teaching that I've developed this. Although, as you'll see at the end, I'll put up a brief bibliography of writings on which I've based some of these ideas, and they will show you that I've been working on this all my professional life as well. But I don't claim, by the way, that this is the method to do comparative law. We all have different ideas that different purposes for which we engage in comparative law. That's perfectly legitimate. There are lots of different ways of doing comparative law. What I do claim is that I've come around to a general method, which I think is very useful. It's particularly useful for helping us avoid making premature judgments about foreign legal systems and dismissing them, or too eagerly accepting them as being somehow better than our own system. In fact, what I really claim is that my method helps you get outside of making hasty normative judgments in favor of being a little more analytic. But there are lots of ways of doing that, and I don't claim you have to do this. The other thing I claim about my system is that it forces you to deal with very important questions, and for that reason, very important questions about any legal system you're studying. And for that reason, it's very useful for teaching. So I really think of this as a general method for teaching comparative law. Not the only possible one, but one that should be appealing to a lot of people because it enables you to introduce the students to really important questions about every legal system. So let me start by identifying what I think are the major analytic skills of comparative law generally. This is something I wrote about years ago in an article called How to Do Comparative Law. I'll have that cite at the end of the talk for you. And the idea is that there are really two major analytic skills that are sort of maybe not unique to comparative law, but that are sort of central to comparative legal study. There are lots of skills, of course. You have to be good at languages. You have to be able to, you have to know a lot about the world, and you have to know a lot about law to really make sense of comparative law. But there are two essential analytic skills involved. And the first is identifying partial functional equivalence. My idea really comes from translation, and after all, comparative law is really a form of translation. It's translating the legal system in one country into terms that can be understood by people in another country, and vice versa. And when we do translation, we are always searching for partial functional equivalence. That is, words in the language into which we're translating that have roughly the same function or same meaning for people as the word we're translating from. And of course, that's a very problematic and difficult exercise, as all of you probably know, because you come from different countries and have worked. Many of you do. I presume most of you probably do. And you have experienced working in languages other than your own native language. And this is very good. That's why language study is such a good basis for legal study in general, and particularly comparative legal study. But again, my idea is that there's a specific skill involved in learning to be very good at analyzing partial functional equivalence, because they're never completely functional, and so you always have to look for things that are partially or similar, and there may be several things in one country that correspond roughly to something you're looking at in another country. The other major skill, and it took me a long time to come to the realization that it really is a skill, and it's a trainable skill, is avoiding premature judgment by suspending your judgment, your normative judgment about something you're learning about in a different system, different from your own, because it's very natural. The first thing people do when they learn about another system is they think, well, is that better or worse than my own system? And people vary. People that are sort of attracted to foreign things, like myself, would tend to say, oh, maybe it's better in the foreign system. But other people resist foreign things on the theory that they really want to preserve their own identity. And both of those are very normal, human, reasonable reactions. The point of my saying that there's a skill involved here is that that what you want to do is avoid premature judgment, and instead of asking yourself, is this system better or worse than my own, it's better to say, well, what are the advantages and disadvantages? Or I often think of them as strengths and weaknesses of the other system and of my own system. And it forces you to think about the weaknesses of your own system and the strengths of the other system, and the strengths of your own system and the weaknesses of the other system. And that gives you a much broader understanding. And you may, in the end, decide, well, maybe they're both good. Maybe they just fit each country's history. That's often what you, I think, come to realize. And you come to realize, and this is very important, you come to realize that many normative arguments that are made all the time in our own legal system are nothing more than statements that we prefer it the way we have it. We'll come back to that later. But that's the danger that comparatives have to avoid. We don't want to just accept our own biases and do comparative law completely out of our own biases. Now, I'm going to illustrate, so that's the comparative method in a nutshell, but I'm going to illustrate it by using an example for comparison. And I picked comparing the U.S. jury system with the system of law judges or lay judges. I guess that's a misprint. It should be lay judges in China. I picked China because I lecture a lot in China, but I actually think that in general I'm talking about lay judges in general in the civil law system, and I will stick in some references, particularly to German law, which I actually know better than Chinese law. But the point is that there's really quite a strong contrast between the way lay people participate in trials in Germany, in the civil law system in general, and in particular in China and Germany, and the way that lay people participate in deciding cases in the United States. So So going back to starting to apply this method in the system, let me say that I've already talked about how my idea of partial functional equivalence is modeled on translation, and I just would give an example. Trivial example is the Chinese word dongxi. Dongxi, east-west. It literally means east-west, but of course it doesn't mean east-west in most times when it's used in Chinese, because it is the standard Chinese translation of the word we use in English, thing, the general word we have for inanimate objects or even ideas or concepts. And the Chinese word dongxi is used in to a great degree, maybe not exactly the same, but in many of the same contexts. So functionally, it corresponds pretty well to the word, but of course there are some differences probably, and those are important for really good, careful translation. One has to be aware of that. A more complex example illustrating my idea of how translation helps inform comparative technique is to think about the translation of the word lay judges or jurors. Actually, let's take the English word juror, the jury system. It's well known. It's well known that that's central to the historical development of the common law. But in many countries, actually in Europe, many countries in Western Europe actually adopted jury system very briefly after the French Revolution. There was a great enthusiasm for juries, but that was quickly given up, and they substituted it with a system of what are called lay judges usually. And I'm going to insist on that difference in terminology just to keep track of what we're talking about. Because as you'll see, I think there are some very significant differences between the way lay judges participate and the way jurors do. So I think of the civil law system in general, and certainly the Chinese system of involving lay people in the decision of cases, as a system of lay judges, and the American system involving people serving on what we call juries, though that's the jury system, and they are jurors. Okay. There are strong similarities between these systems, starting with the fact that they both are mechanisms for getting some significant participation by lay people in the decision of important court cases that are obviously important, at least to the parties. There are undoubtedly lots more things that could be said about similarities, but sorry, I lost my cursor here. There it is. Let's talk about some of the differences, because they're quite striking, I think. In the U.S. jury system, jurors are chosen for one specific case, and if they get chosen for that case, they decide the case. If they are not chosen for that case, they may be subject to being recalled in a future case. But if they actually serve on a case, usually they have some period. I think in Iowa it's 2 years when you can't be called again to be on a jury. But after that, you're again subject to possibly being called according to systems of a lottery system or other forms of random selection. But in China, lay judges are chosen for a fixed term, and they may hear multiple cases within that period. They actually act like judges in that sense, that they have a job of listening to those cases. As my understanding is that prior to 1983, the lay judge system was required in Chinese courts, but since 1983, the courts have discretion to decide whether to use lay judge system. And I have understood, although I don't really know whether this is right, maybe some people in the audience can tell me, that it's been a bit difficult in China to necessarily have enough lay people who were willing to serve to staff the lay judges, so that maybe they are no longer being used as much as they were for a while. In the U.S., litigants have a constitutional right to have a case that is triable to a jury that was triable at common law. It's a very strange rule that requires a counterfactual historical inquiry into whether a cause of action that exists today would have been tried before at the time the English law was received in the state to which we're talking about. So in the first 13 colonies, that would be before the existence of the U.S. And they have to, the court has to figure out whether it makes sense to allow juries in some cases, particularly we're particularly talking about causes of action that are the product of new regulatory statutes. But with regard to old causes of action that were long been recognized in common law, like breach of contract or tort claims, those are triable by constitutional right to juries, and so the parties have a right to have a jury, although they can waive it. And actually, more and more parties do waive the right. The juries account for a smaller and smaller proportion of our tried cases nowadays. But perhaps the most important difference, in my mind, is that, or certainly one of the most important differences, is that jurors decide only factual questions. That is, in the American jury system, the jurors decide only factual questions, except that they also decide the ultimate mixed law fact question, which is really the question at the heart of every legal case. So, for example, in a criminal case, the jurors decide guilt or innocence, and in a civil action, they decide the question of whether the person is civilly responsible or not, and if so, the juries decide the amount of damages in most civil cases. They don't decide the amount of punishment in criminal cases, except in a capital case, the jury has to choose separately for the death penalty. In the system of lay judges decide all issues with the professional judges. They are treated as if they are judges for the purpose of that case. Now that might seem to give them extraordinarily powers, but my view is that, and this is maybe the most important difference between juries and lay judges, juries perform their function and decide the questions that are remitted to them. They decide them entirely away from the influence of the judge. The judge is not allowed to meet with them separately. The only way the judge can communicate with the jury is in open court, where both parties are represented and available to be represented. And so it's very difficult for the professional judge to influence the jury very clearly about his or her view of the case. And I think it's fair to say that judges in the United States really try to avoid that, because if they are deemed to be influencing the jury, that's considered a major ground for a retrial. In the lay judge system, the lay people sit with the judges and deliberate, and I think this makes all the difference in the world. I think that, and I'm not alone in thinking this, I think it's common view among comparatives that professional judges have much more opportunity to influence the decisions by lay judges. That's not to say that they completely control them. I think that it's very true that in some systems, lay judges can outvote the professional judges, but they have a lot of tools to try to prevent that, I think. We'll talk a little more about that in a minute. Now, in terms of avoiding prejudgment, I've already talked about the basic ideas. My idea is simply that it's very normal and human, natural to think that to be somewhat resistant to the foreign system, or to be overly eager to accept it. In either case, it's difficult to maintain your balance, to have a very clearly analytic and cool view upon which to make a decision about the relative merits, or I wouldn't even put the question that way. I would say about the relative strengths and weaknesses. And so as I said, I think the idea is to talk about strengths and weaknesses, or disadvantages and advantages of each system, and try to appreciate it in that way before you make a judgment. So, for example, applying it to jurors and lay judges, one outstanding problem, one obvious problem with the jury system is that it's expensive. Originally, we required 12 jurors for every case. Now the Supreme Court has interpreted the Constitution to allow smaller juries in some cases. Federal juries are still generally 12 people, but in many states, juries have been reduced to 8 or 9 members, and in some cases as few as 6. The lay judge system in China requires either 2 side judges for a court with 1 professional judge, or 4 lay judges with 3 professional judges. And as I said, the Chinese judges are chosen for a term and may hear multiple cases, whereas the jurors in the U.S. are chosen for a single case and hear that case only. So in fact, I was going to mention that in my 38 years of living in Iowa, I've been called 3 times to serve on a jury. I actually ended up serving on that jury in each of those times. I guess maybe I was called additionally 1 or 2 times and didn't get picked. So there are far more lay people being exposed to the court system through the jury system because they call huge numbers of people down. To get a jury of 12, they typically call 20 to 30 people, probably 30 people at least, 30 to 50 people in to make sure they can find people who don't have conflicts with the case. I mentioned already that lay judges sit with the professional judges, and so in the two lay judges, one professional judge, or even the 3-4 model in China. In both cases, while the lay judges may outnumber the professional judges, we think that as a general rule, they don't control the judges. It's very difficult. Let's put it this way: it's very difficult for the lay judges, the lay people, to effectively counter the professional view if there's a disagreement. Now, of course, in a lot of cases, there's no disagreement. But I think, in my view, the really predominant feature of the lay judge system is the fact that lay people are sitting there with the judges deliberating. So the professional judges can correct, or at least seek to correct, any misimpression about the law, or if there is unhappiness with the law. If the lay people show some resistance to the requirements of the law, the professional judges, we expect, will probably put some pressure on them to follow the law. That may be a good thing. I'm not arguing it's a bad thing necessarily, but it's different from our system, because in our system, the professional judge is not in the room with the lay people. The lay jurors can decide they don't like the law at all. In fact, we talk about jury nullification. Jury nullification is much more possible in the American system than it is in the Chinese system, because in the Chinese system, the professional correction is right there in the room. And also, think about this: in China, all courts have to write opinions. That's a good thing in general. We think it limits arbitrariness, but it also gives the professional judges a real tool to use against lay judges who want to who have a different view of the facts. For example, if in the professional judge's view, the lay people's view of what happened is not sustainable on the evidence, well, they say to him, well, so how are we going to write this opinion? And it's the professional judge who has to write the opinion. So he can use that as a tool to kind of at least nudge, if not coerce, the lay people into doing what the professional judge thinks is required by the evidence. Well, we can debate whether that in fact happens or not, but these are the sort of issues that I think you need to think about in terms of strengths and weaknesses. I'm not saying that necessarily I know exactly that my view of the strengths and weaknesses is necessarily right. That's always a debatable issue, but that's the kind of analysis I think that I would like to see people doing before they try to decide which system do I like or which system do I think is better. Okay, and just to complete the thought about jury nullification, it's a very controversial topic. As you may know, lawyers and judges are not allowed to tell the jury that they have the power of jury nullification, but they do have that power, and some of them will figure that out. Of course, we assume in most cases the juries don't try to nullify the law. The jury system would fall apart if really that was the norm. But in important cases where the jury is unhappy with the way the law has been shaped, it does have the effect of allowing the jury to keep the result in the court closer to the general population's view of justice than the law would appear to require. Now, that may be good or bad, but it's different. That's my main point. A little talk about the advantages of the jury system. One big advantage of the jury system is that it insulates the professional judges. When there is a when there's a person with a lot of popular support or political power within a community who has done something wrong and the evidence shows that they should be convicted, the judge, the professional judge, doesn't have to do it and then take the brunt of the popular anger. The jury does it. And although we don't necessarily hide the jurors' names, it is much more difficult to get their names, and in general, that has, on occasion, been cited both by judges and by non-judges as an advantage of the jury system. It diffuses responsibility, and it takes responsibility in some very hotly contested cases, where the contest was really on the facts and not on the law. It takes that away from it shields the judges from being responsible for that. I also would just note to you that the jury system is a striking testament to a strong belief in the essential common sense of the common person. And I often hear my foreign students say to me, "Well, we can't have that jury system in our country. Common people aren't to be trusted. We couldn't trust their judgment in these things." Well, that may or may not be true. Sometimes people feel that way here in this country too. But I just, whether it's right or not, I'm saying the American jury system is a striking vote of confidence in the common person. There's also a good bit of evidence that service on juries actually enhances citizens' commitment to the state and the legal system and the political system that it represents. Now, it may be that service as a lay judge does some of that same thing in countries like China and any all civil law countries that have that system. I think the only thing I would say is the jury involves more people than the lay judge system, or at least it would if we used a lot of jury trials. There's a good question about how many jury trials we actually still have in this country, and it may be that eventually that I can't really show empirically that that statement is correct. It has been correct in the past. Now, what I want to suggest is that in the other important aspect of sort of avoiding premature judgment is to try to understand, once we've talked about advantages and disadvantages, the other really key part of my method is to try to understand the differences that we observe, to try to figure out whether they are parts of general patterns of difference between the countries we're comparing. In other words, my idea is that law is simply one element in the pattern that many countries use for the structuring of society. Law is part of the governance system, but the governance system is broader than that. It's a political governance system as well. And And there's aspects of the way the economy is organized and the way society is organized in general that also will reflect these patterns. So I have actually suggested that there are three broad patterns, and that's what's listed here on the in the last point of my outline. And these three broad patterns are not the only important ways in which countries differ, but they are ones that are particularly important for looking at legal systems. And so I suggest that, again, before we make any judgments about which system, which rule we like best when we're comparing legal rules or legal institutions, we ask ourselves, do these differences that we can observe, do they track sort of general patterns of difference among countries that make sense? And my thought is, if they're part of a general pattern, then that shows that the country really makes a fundamentally different judgment than the one we're used to with respect to the values that concern that. And so we should take it seriously, even if we don't agree. I'm not saying you have to agree with the foreign pattern. we all come out of, we live in our own patterns, but we need to understand the logic of other patterns, and maybe by seeing that it's part of a broader pattern, I guess my main idea is that then we will automatically respect it more because it's a more significant aspect of that country. So I think there are three broad patterns or types of patterns that I'm particularly interested in, and the first two are really related. They both are aspects of what we often refer to as the rule of law. But rule of law is a very controversial term in the current world because it's bandied about by many different countries, and it means a lot of different things to different people, and it comes with a lot of baggage relating to the Western world's development of the rule of law and the use of the rule of law in colonial systems and other systems of oppression. So I thought, well, let's not talk about rule of law, but what are some of the important ideas at the base of rule of law that we are concerned about and that really do relate to all legal systems? And so I broke down rule of law into legal autonomy and legal sovereignty. Legal autonomy is the claim that law is in some significant sense independent from other forms of political control. Let's face it, law is a type of political control. It's a tool of political control. But countries have many different aspects of political control. But one important pattern is how significantly the legal system is independent of those other forms. In some countries, the idea has been that law should not be independent at all. And of course, that's largely the view in China today, that law is ultimately should be subservient to the people's will expressed through the National People's Congress and through the communist people's the PCP, the Communist Party of China. In the United States, we have this idea that law really is an important tool, an important way of disaggregating power. We think of the legal system as being an independent branch, co-equal with the legislative branch and the executive branch. And so we have a very different view about how law should be, where law fits into the pattern that's used to describe the distribution of power. China is a very centralized, has a very centralized ideal system anyway, although maybe that's counterbalanced by the reality that China is such a big country that it's impossible to completely govern it from the center. And the United States has this very different view that power should be broadly distributed, and law is one of the main ways in which it's distributed, so that we've created very independent courts. We've put a lot of effort into making sure our judges are independent from any political influence and any influence by the parties themselves or by strong groups within the society. The only way they can be influenced is through open argument and open court. And then the sort of flip side to legal autonomy is the question of legal sovereignty. That's kind of a grand term. You could, sometimes I'm tempted to just call it jurisdiction, because what I'm talking about is the power of the legal system to set limits to the exercise of power by the political branches. And so what does that mean in concrete terms? It means constitutional law and administrative law. The power of the jurisdiction of courts to pass on the constitutionality of legislation and to pass on the constitutionality and legality of administrative action. That's what legal sovereignty is, the power of the courts to influence that. And not every country accepts that there should be, for example, constitutional review by courts of legislation. More and more countries have accepted that in the second half of the 20th century, but China still resists that idea, and there are other countries in the West that resist that too. England resisted it right up until 1998, when they finally accepted, under the pressure of the European Union, they accepted the creation of a kind of judicial review, but it's a distinctly different and some would say weaker form of judicial review, because they denied the courts the power to invalidate statutes. They just said you can opine that the statute is unconstitutional, and in that case it will put pressure on Parliament to amend the statute. But you actually have to apply the statute if you come to the conclusion that there's no way you can interpret it to avoid invalidating the constitutional, invalidating the statute. There's no way to make the statute, to read the statute to be consistent with the constitutional requirements. In England, that's a statutory Bill of Rights. Then they have to, if they possibly can read it consistently, they have to read it that way. But if they can't avoid the conflict, they have to apply the statute. But they can opine that it's unconstitutional, and that should put pressure on Parliament to amend it. That's the idea of the so-called Commonwealth system of judicial review, and New Zealand has adopted that. Canada has something that's sort of halfway between the American system and the British system, because they provide for legislative override by the legislature. The legislature can say, no, we really mean to violate your constitutional rights. You have to apply the statute despite your rights in the Charter of Freedoms in Canada. So there are different approaches to legal sovereignty. Not everybody agrees with the American version by any means, although America and Germany I would cite as sort of the extreme examples of legal sovereignty. And then the last, and let me just say, with regard to legal autonomy and legal sovereignty, they are perhaps less clearly involved in our discussion of jurors and lay judges, except that I do think that the jury system undoubtedly has contributed greatly to the claim by American courts to be independent, because when the jury decides, it's not the professional judges who are deciding the case ultimately. It's a group of private citizens who have concluded, after they were instructed on the applicable law, that the defendant is guilty or is not guilty, or has to pay a certain amount of money. So those are decisions which make it give the court the close the court with the apparent approval of society, and I think that's a powerful way of making the courts more independent, or giving them the political strength to withstand attacks on them. And by the way, there are always attacks on the courts in every country, but particularly in democracies, there's constant dissatisfaction with courts. The last point that I want to cover is political economy. And I see I'm running out of time here, so I'm going to have to be short here. but political economy is what I've spent most of my career writing about. The idea of political economy is that the nations of the world are in a they have a there's a spectrum of political economy. Let me put this in my screen. I think you should now be able to see. I'm sorry, I always have a problem losing. My mouse isn't working too well, so I've kind of lost my cursor here. Where is it? There it is. You should be able to see the political economy spectrum now, I hope. And my idea is that the nations of the world fall on this spectrum from the command economy over on the extreme left-hand side to the laissez-faire economy on the right-hand side. I guess there are no true examples of either of those extreme points anymore in the world. The countries that had command economies were typically the socialist communist states, and they have all introduced substantial aspects of free market economy, although none of them would be totally improper to say they've all become free market economies. But they've certainly moved in the direction of having much more of the economy being subject to free market principles. And the U.S., by contrast, is certainly, no one could say it, we're really a truly laissez-faire country. But laissez-faire exerts a very strong attraction in the United States still. There are many people who argue vociferously against state intervention in most things. And so big plans of state intervention, like all the state aid for victims of the COVID pandemic, or going back to the earlier financial disasters we've had back in 2008, similar problem when massive state aids are suggested, particularly when they're aimed at individuals. There's an enormous amount of political resistance to that in the United States. So we are a system that prefers to use the free market as much as possible for the determination of the allocation of goods and services, and we're very skeptical about the state use of that. So we're at one extreme end, and I would argue to you that the U.S. is probably the most extremely market-centered political economy in the world. And certainly the old socialist economies, although it would no longer be correct to describe them as command economies, they have moved substantially in the direction of incorporating much more free market activity. But China, for example, still has enormous amounts of state-owned enterprises, and this is a big problem for its economy and for figuring out politically how to go about restructuring those. Russia has done a little more of that because a lot of their state-owned enterprises fell apart, and they stopped providing social services, which is what a lot of them were being relied on for. But it's still got a fair number of state-owned enterprises. State-owned enterprises are less common as we move to the center of the spectrum, and I see the democratic welfare states of Western Europe as being pretty much in the middle of the spectrum. My American audiences don't usually like that because it suggests somehow that they're more moderate than the United States. Well, we're not so moderate. We're really pretty radical when it comes to rejecting government intervention in the market. So this is a big generalization that I make, and I've written quite a bit. I'll put up my writings in a minute. My claim with respect to juries and lay judges is simply that the jury system is a more deeply it involves deeper deeper intervention in the state by private bodies. So it's a way of you can think of the jury system in the United States as a way of sort of disaggregating state power. And although the jury system is not a market system, it works in a similar way in the sense that instead of having jurors spend money, they each have a vote, and the jury system uses a voting system, but it represents the the skepticism about the state authority. The jury, I think you can see, really is set up in the United States, particularly with the way we shield the jury from control by the professional judges. It really operates as a system for limiting, checking state power. And so in the end, it certainly is partly a very strong representation of American distrust of government officials in general, including judges, even though we give our judges an enormous amount of power and are often accused of giving them too much power. We actually don't trust them very much either. We don't like to trust any state officials. We have a very strong skepticism of the state, and I think the jury reflects that. The lay judge system does not reflect it as strongly. It may have some of the same elements in it, but it's certainly a weaker system. So in that sense, I think it pairs, it can be understood, you can make sense of it by thinking about these broad patterns of political economy. And I know I've talked too long here, so I'm going to stop at this point and ask if there are any questions. But while you're thinking about that, I'm going to put up my bibliography that I promised you, in case anybody is interested in reading more of the things I've written about this. I haven't really written a full statement of this. I'm actually eventually going to publish a book spelling out this general system. But I have written some general things. I'll just say a quick word about my publications. There's, of course, my How to Do Comparative Law book that I mentioned a long time ago. I also, this article I published in Tulane quite a few years ago, despite the fact that a title makes you think it's just about political economy, it actually has a last section that's all about legal autonomy and legal sovereignty as well. So it's probably the major place where I've explained my idea about all of these different families of legal principles or families of patterns that help us make sense of differences. And then I've got writings that are focused on political economy, quite a few, because that's been the major focus of my attention so far. And then a few where I have talked about models, sovereignty and legal autonomy. So I apologize for talking so long. Let me ask for if there are any questions.
Yes, thank you very much, Professor Reitz, for the lecture. And we do have a lot of questions, but before we go into that, I think Professor Goodwin would like to say a few words.
Oh, great.
Yes, I just wanted to, on behalf of Indiana University Maurer School of Law, thank you for your visit, your fascinating lecture today. I have to unfortunately run to class right now, but I found your talk very interesting. And as someone who studied linguistics before going into law, your discussion of of law as discourse or law as translation, I think really hits home for me anyway.
Oh, great. Thank you.
I am advisor to and teach the SJD students at the law school their first course, and so comparative law is obviously a big part of that. And so this has been really helpful for me, and I think for many of the students that are here for the webinar today. I think you're going to get a lot of really interesting questions. And I'm sorry I can't stick around for that, but thank you so much, John, for being here. And I hope we'll be in touch again.
I hope so too. Thank you very much, Gabrielle. I appreciate that. You're welcome. I'm sorry I can't be there in person.
Yeah, me too. But
Yeah.
bye all. Thank you.
Goodbye. I am willing to stay around, though. I know this is supposed to end at 1, but if there's desire to stay around, I'm happy to talk.
Yeah, we have several questions, and maybe you can answer some of them right now.
Sure.
Great, thank you. So we have a question from, and forgive me if I don't pronounce it correctly, Abraham Alariani. He asked about his dissertation topic about the recognition and enforcement of foreign money judgment in the United States and Saudi Arabia. His aim is to examine the possibility for the two countries to reach an agreement on this matter by discovering how each country deals with each other country's judgment. So his question is, in comparative research, what would researchers do more than describing the similarities and the differences between the two countries?
Well, applying my method, I guess I'm saying you start by identifying similarities and differences. That's always the core job of a comparatist. And then you ask yourself, with respect to the similarity, I didn't talk so much about similarities, but similarities can be interesting too. I'm mostly interested in differences. That's what I spent my life working on. But similarities can be important too, because similarities suggest that maybe there's a common, a general, or we might even say universal aspect to the problem. You know, if all the countries have the same, basically the same rule about a subject, that suggests some very strongly generalizable, maybe universal aspect of humanity that's reflected by that rule. So that's something to think about. Is there, with regard to the similarities, is there some, and with regard, you know, he's dealing with a rather technical topic. So when you're thinking about a technical topic, maybe you don't get to real questions of humanity, but you do get to questions about this topic, about enforcing judgments. What is it about enforcing judgments in any foreign legal system that is going to be a common problem? So similarities might help you identify things that are almost necessarily part of the system. But then let's focus on differences. As I said, they're usually more fun to talk about and more interesting and more challenging. What do we make of the differences? Well, I would suggest that in this more technical area, probably those differences, I would suggest he should be doing what I suggested as a general part of the pattern, which is ask yourself, once you've identified the differences, first, okay, what are the obvious problems with each side's different solution? Are there ways in which they are inconvenient in that system, or create problems, or create injustices? We should be very concerned about injustices. And of course, with a really technical problem, it may be very difficult to discern that. Technical issues have a way of hiding the justice issues. So I think that's a real challenge for people working in a more technical area. But you want to say what are the either the disadvantages or the weaknesses. You can look at it either way. Weaknesses, strengths and weaknesses is a little bit of a it presumes a normative base, and so we are trying to get away from quick normative judgments. So maybe it's best to talk about disadvantages and advantages, and there may be some advantages, disadvantages, or advantages of the rule in country A that are really the product of general ways in which their legal system works, or at least the way the law works in this area, having to do with court enforcement of judgments and that sort of thing. There may be aspects that are sort of unique to that are the fact that there are disadvantages or advantages is related to a lot of other aspects of the system. Well, that's the kind of analysis good comparatives should do, trying to understand how what they're looking at fits into the broader picture. On a related note, I spent some good time with Professor Grossfeld in Germany many years ago, 25 years ago, and he used to talk about how some scholars would come. He had an institute where lots of foreign professors came and studied, just as we have an institute, we have a library, law library at Iowa and we try to host lots of foreign scholars who want to do serious comparative work. If you're interested in that, you're always welcome to send me an email, and we'll see if we can possibly accommodate you. But he would say about some of these scholars, he said they would come to Germany to study one rule, and that was what they wanted to study, and they didn't want to study anything else relating to it. And what I'm suggesting is really good comparison has to be taking a broad view, trying to look at as much as you possibly can. Of course, we can't all know everything about everything. None of us can. So you do have to have some focus. I don't want to make fun of people who are highly focused, but you want to make sure that focus isn't so narrow that you're missing broad patterns. And so my suggestion is you take that narrow technical question and you start looking for starting with disadvantages and advantages, but then trying to understand, okay, are these advantages that are linked to stronger systems that are either so broad that there's no way you can change them, so you're stuck with these, or maybe they reflect really important political values. For example, political economy, I think, is the easiest to understand in that sense. When there's a strong commitment in the United States to the more market-centered political economy, a strong distrust of government, a strong wariness about depending on government aid, and that affects all our thinking. I'm not sure that's good. And we don't have to accept it. You can argue against it, but you need to recognize it. It's a very strong fact of American culture that we have this dominant view that the government is not to be trusted, and we want to minimize our reliance on the government. And so that's the way to give some depth to any sort of study.
Thank you for this for the answer. So we have another question from Alan Cole, and Alan Cole asked about how, Professor Reitz, your research on how do you do comparative law has gradually evolved over the past few years.
Oh, well, that's a good question, and I'm not sure I've taken adequate stock of what I've done to really figure out whether I can answer that completely accurately or not. But my sense is that, you know, I've had this long time interest in political economy. I started, if you look on my publication thing, I think my earliest paper was 1990. No, the earliest one was 1999. Yeah, the piece I did on judicial review, political economy and abstract review. And that's when I tried out the idea of political economy, and I have definitely tried to refine that idea over the years. I think probably that my ideas then were fairly simplistic, and I've struggled with the terminology and with trying to define things a little more carefully. So that's been one thing. But I think the biggest impact on my teaching has actually, on my scholarship, has actually been my teaching. By teaching a general course in comparative law, I don't teach it every year. In fact, in recent years, it's been more like every other year. But I think that is a really important, for me, it has been a really important stimulus to working out what I mean by comparative law, what I think matters in comparative law. But as I said, I'm very resistant to I don't want to be understood to be saying this is the only way to do it. We have far too many scholars who write pieces suggesting that, and we don't need more of that. I think this is a valuable way to do it, and it's the way I've been able to provide, I think, for my students at Iowa, which is a small, middle-sized to small law school, where there never are big classes of comparative law. It's always been a small class, although as Gabrielle said, the SJD students increasingly are an important part of that student group that needs to study comparative law. But at any rate, that teaching has really pushed me to refine my ideas better.
Okay. Yeah. So our final question comes from Professor Mary Luz Paris, who is also the other speaker for this series. Yeah. She'll talk about how to compare the constitutionality. And we're trying to make her ask live. But in the meantime, her question is about that the legal families have, whether you think that the legal families have evolved in terms of categorization, like away from the traditional common law and civil law jurisdictions.
Well, yes and no. I think there has, you know, there's been a lot of criticism of the common law civil law divide, as if and as if that's been superseded by events, and I don't believe that at all. I think that the fundamental, I actually, in my comparative law, I spend quite a bit of time on the historical development of the difference. So we study how the civil law developed from Roman law and how it involved the development of the the jurists first in Roman law, but then the legal scholars in Bologna after the rediscovery of the Roman law. I want my students to understand that the civil law tradition reflects this strongly academic approach to law, and that academic approach is continued to be developed in such things as legal science, what the Germans called legal science, which involved this idea that you could deduce all legal rules from sort of basic principles, and that everything should make Euclidean sense, so to speak, so mathematical sense. And they tried and did an amazing job of reducing much of particularly civil law, that is non-constitutional, non-criminal law, to or even criminal law to these sort of Euclidean geometric principles. And that, even though that's, nobody teaches that exactly that way anymore in Germany even, nevertheless, that tradition has had a huge impact on the status of legal scholarship, on the role that it plays vis-a-vis judges in cases, and on the idea that Germans have, and other countries that have been strongly influenced by Germany have, of the proper methods of interpreting statutory law, and how statutory law has to be supplemented by what the Romans called jus, by the general understandings of law, what the Germans call Recht. And so I think that is enormously important. France has a different tradition, a little bit different tradition, but actually it reflects that same concern for very strong logical basis, which is strongly rooted in statutes. So my understanding is that although we all understand, everyone, all the traditions are in communication with each other now. There are comparatists like us everywhere, and they have some understanding of other systems, and we all have only partial understanding of whatever we study, because you can't know everything. Still, some of these ancient differences, or differences that reflect the history, but maybe are modern differences, they remain very important. My understanding, for example, is that on the International Criminal Court, people spend enormous amounts of their time every day debating how to mesh civil law traditions about criminal procedure with the common law traditions, because they reflect very different approaches to the legal autonomy, legal sovereignty, and political economy. So these differences between legal systems are, we have to be very cautious about ascribing everything to a difference between common law and civil law. It's by no means true that that's the key to understanding everything, but it's still a very important key. There are other valid ways of classifying legal systems. Federal systems are very different from, some federal systems look very different from more highly centralized systems, although that's an area where partial functional equivalence analysis is very important, because things can call themselves federal and not actually be very federal, like the Russian system, for example, which is really not a true federal system. So we have to be careful about terminology. And in the end, every legal system is somewhat unique. Just because you know a lot about German law doesn't mean you know everything about French law. Just because you know a lot about German law doesn't mean you know everything about Japanese law, although German law was very strongly important in the formation of the modern Japanese legal tradition. But of course, it's Japanese law, it's not German law, and there are new ideas, and there have been influences from the United States as well, and also from traditional East Asian traditions about law. I think legal families are very useful for a lot of things. I always teach my students about the various questions about legal families, and we always learn about common law and civil law, and we learn that I have a session where I try to show them the continuing relevance of civil law common law divides, but I make it very clear to them that there are lots of other important ways of understanding the differences.
Right. Thank you very much for the answer. So we still have a lot of questions, but we have reached the end of our session today. Thank you very much, Professor Reitz.
Well, thank you.
For delivering the lecture and lingering around to answer questions. And thank you everyone for attending this event. Our next lecture for comparative law will be on March 18th. Professor Mary Louise Paris will talk about the methods to compare constitutionality. Again, if you're interested in other events hosted by Law Science, feel free to join the mailing list by clicking the link we have shared in the chat box. All right, thank you very much.
Thank you very much, everybody. Thank you.
All right, thank you.